Good evening. Welcome to UNH School of Law. My name is Erin Corcoran. I'm the director of the Law School's Social Justice Institute, and we are absolutely thrilled to have you all here this evening. Tonight is our inaugural Norman Stahl lecture series, and our featured speaker is Jonathan Lippman, the Chief Judge of the New York Court of Appeals. And before we introduce our speaker and our honor guest, I wanted to make a few opening remarks. This lecture is the last in a series of lectures where we've had 3 chief judges from different courts, state courts in the country speak. And all of it has been also centered around the law school's efforts to heighten the importance of pro bono work. So the week of October 21st was Pro Bono Celebration Week at the American Bar Association, encouraging law schools around the country to talk about the importance of law students and lawyers doing pro bono work and services. We decided, the Social Justice Institute, along with several student organizations, including the Public Interest Coalition, to have our pro bono work center around Bruce Friedman, who is a professor here and a champion of legal services and pro bono work. So we had a friendly competition here at the law school where student groups were encouraged to compete to see which student group could log the most pro bono hours in a 2-week period. We logged over 63 pro bono hours in total. 18 student groups competed from the school. And so before we get started, I'd like to just take a couple of minutes we're going to honor both the group that logged the most pro bono hours as well as the individual student who logged the most pro bono hours. So first, we're going to give the Bruce E. Friedman Pro Bono Student Group Award to the Public Interest Coalition. And I'd like to ask Scott Whitaker and Sarah Crisp to come up and accept this award on their behalf. This is a basketball. And for those of you who know Bruce Friedman, there is no need for further explanation. Bruce Friedman was an avid basketball player, played pretty much every day of his life. And so in honoring sort of his spirit and who he is, we will be giving this award to the Public Interest Coalition, and it will move to whatever group next year completes the highest number of pro bono hours. So thank you very much. Oh, it's Jessica. And I'd like to ask Amy Abelhoff to come up here and accept the award. She logged 6 pro bono hours. She's a 1L, so 6 hours in 2 weeks. And I also just wanted to take a moment to recognize that we have quite a few of Judge Norman Stahl's law clerks here in the audience with us today. You can recognize them and identify them. They're all wearing orange carnation boutonnieres, and some of them have traveled as far as DC to be here with us tonight, so we're really honored to have them here. So I'm actually going to ask John Graby to come up and talk a little bit about Judge Stahl and the importance of this lecture. He himself is a professor here at the law school and also was a former clerk of Norman Stahl. So thanks, John.
Thank you very much, Erin. Well, I'm so pleased to welcome all of you here to this, our inaugural lecture in a series that will honor my former boss, Judge Norman H. Stahl of the United States Court of Appeals for the First Circuit. Judge, I see in the audience, and I'm sure you see as well, many of your judicial colleagues, former partners, former practice colleagues, present and former law clerks, those of us wearing boutonnieres, student externs, friends, and of course family. This fine turnout on this crummy night speaks volumes about the great number of lives that you have touched. Everyone, it is my honor to say just a few words about Judge Stahl, for whom I had the privilege of serving as a law clerk for 8 years. I was actually a permanent elbow law clerk to Judge Stahl. 8 years being pretty permanent in the world of clerking. As many of you know, Judge Stahl is a native of Manchester, New Hampshire, and deeply, deeply loves this state. He received his BA from Tufts University in 1952 and his JD from Harvard Law School in 1955. Following law school, he spent a year clerking for Justice John V. Spaulding of the Massachusetts Supreme Judicial Court. But then, upon completion of his clerkship, Judge Stahl returned to New Hampshire and began practice with the law firm that I knew when I came to New Hampshire as Devine, Millimet, Stahl, and Branch, but which is presently known simply as Devine Millimet. Judge Stahl practiced there from 1956 until 1990, when President George Herbert Walker Bush named him to the United States District Court for the District of New Hampshire. In 1992, President Bush elevated Judge Stahl to the United States Court of Appeals for the First Circuit, where he took the seat that had been very briefly, and I mean very briefly, occupied by David H. Souter before Justice Souter's elevation to the United States Supreme Court. This past September, many of us here in this room were privileged to attend a conversation between Justice Souter and PBS's Margaret Warner. The title of the talk was, "How Does the Constitution Keep Up with the Times?" Now, during that talk, Justice Souter emphasized the importance that the facts, okay, he emphasized this on a number of occasions, the importance that the facts play in the course of sound legal interpretation. Now, when he was referring to the facts, Justice Souter did not mean, or certainly did not simply mean, the who did what to whom of the case before the court. Because Justice Souter is emphatic in rejecting the notion that a judge engaged in sound constitutional interpretation is merely an umpire who applies the rules to the case facts in much the same way that a home plate umpire calls balls and strikes. Instead, when he was referring to the facts, Justice Souter was talking about that crucial element of legal reasoning known as the social background facts, which are the understandings about society, the human condition, and how the world works that judges are inevitably called upon to apply in deciding difficult cases. Now, when Justice Souter made reference to the facts, I immediately thought of you, Judge. And I thought of how you used to tell us that the facts are everything in a difficult case, and how much I've really come to agree with that. Judge, your judicial contributions are many, and I risk doing you a disservice by focusing on a single one. But to me, at least, your understanding of the facts of life, the facts experienced by ordinary people in smaller states such as New Hampshire, always struck me as exceptional, and really as your unique contribution to the judiciary. Time after time, you would come and tell us clerks about the story behind the story in cases involving everyday issues, okay, business development issues, finance, employment disputes, bankruptcies. And your knowledge about these things was absolutely indispensable and unmatched, okay, and it led, I believe, to the wise disposition of the cases that we all worked on. In a similar way, I think that your experience growing up Jewish in a decidedly non-Jewish state always informed your receptiveness to claims on behalf of outsiders. Okay? You've always been particularly sensitive to doing the right thing in claims brought by immigrants, claims brought by asylum seekers. You have a sympathy for free expression and the separation of church and state, and for keeping government within the proper legal boundaries. That is, I believe, going to be a very, very strong part of your legacy. On a more personal note, you have always been a kind and generous mentor to those of us who were lucky enough to work with you and for you. Through births and deaths, career advancements and setbacks, you have always taken a keen interest in each one of us, in our wives and husbands, and in our children. And you have always stood ready with wise counsel and done all you can to promote us in our careers. You have been everything that any lawyer could ever hope to be, and it is most fitting that we honor you tonight. Thank you for everything. At this point, it is my great honor to introduce John Broderick, the Dean of the Law School, who will introduce tonight's speaker.
The exams will be passed out. Nice to have all of you here tonight, and it's a real honor to have Norman here tonight, and Sue Stahl, and their daughter Ellen. John made the formal introduction of Norman, but I just want to take 1 minute because I was an associate at Norman's law firm. I was a partner of Norman's at the law firm. I became a friend of Norman's at the law firm, but he has always been a mentor to me, whether he knows that or not. He was always interested in your life and always there to support your life. Joe Millimet was an extraordinary lawyer, and Norman is at the same hierarchy in my mind. His career here, for those of you who didn't practice with Norman, was extraordinary. His time on the court has been its equal, but I wasn't with him on the court. I'm so honored that we have this lecture series, Norman, for you. My job is to introduce tonight's speaker. And let me say, I want to thank the members of the federal court, the state trial court, the state Supreme Court for being here tonight. You honor Norman by doing that, and you honor our speaker. Jonathan Lippman is the Chief Judge of the New York Court of Appeals. I met him just a few years ago while I was still on the court, serving as the Chief Justice. He followed Judith Kaye, who served as Chief Judge of the Court of Appeals for an extended period of time, who was a nationally recognized and respected advocate for children and widely respected in the Conference of Chief Justices. So I didn't envy him following her. But let me tell you, in a very short period of time, he has cut his own path in a way that is respected nationally and among all his fellow chiefs in the United States. What impressed me most about the Chief Judge of New York is his interest, his sincere interest and dedication to access to justice issues for all people. I'm also impressed that he got a pay raise for the judges in New York, which I thought is incredible. But he won't be remembered for that. He'll be remembered for his singular focus on access to justice in American state courts. And for those of you who work in the state courts, you know what I'm talking about. It's a crisis in American courts. People who go it alone. And it's not going away. And Jonathan Lippman has been a giant on that stage and a wonderful friend to me. Before I ask him to come up, I want to tell you a story, which I hope is funny. About 3 weeks ago, the chief and I were at the University of Maryland to speak at a SALT conference, Society of American Law Teachers. And it was in a room much like this, and right outside the door was a bathroom, a men's room. So I went into the men's room. I hadn't met the chief at that point, and I was washing my hands, and suddenly I felt a hand on my shoulder, a little edgy. And I thought, is that a hand on my shoulder? And so I turned, my hands are dripping wet. Now the door to the men's room is there at this point. So I turn, and the chief embraces me and puts his cheek on my cheek. My hands are dripping wet. And I'm looking at the door thinking, oh, please don't. Don't open. Jonathan Lippman is a graduate of NYU and NYU Law School. He served the New York court system for almost 4 decades. He was appointed by Governor Paterson in New York to his current position as Chief Judge of the New York Court of Appeals. In my time in judicial service, I met a lot of people who are judges. But I met very few people like Jonathan Lippman. If you had a case that you wanted someone fair and smart and decent to decide, if it was your case, you couldn't do better than Jonathan Lippman. When I asked him to come, knowing he had nothing on his schedule, he's only the Chief Judge of New York, he didn't hesitate. He left home today in the rain. He's leaving Concord to drive to Manchester at 5 a.m. tomorrow morning. He came only to be here tonight so we can honor Norman Stahl and his service. Jonathan Lippman is a name you will hear over and over in the years to come. I'm very proud that he's here, and I'm proud he's my friend. I'd like to introduce the Chief Judge of New York, Jonathan Lippman.
It's really a delight to be here, and you know, we've been kind of through the mill in New York the last week to 2 weeks, and this weather looks good to me. But I do want to say that, you know, when you have the kinds of events that we had with Sandy, it only brings home to me how important the subject that we're going to talk about tonight. I think that when human beings are in distress and there is suffering, that's really, in so many ways, when the legal profession is called upon to be at its noble best. And you know, I come here tonight with that as kind of a framework for the issues we're going to talk about, and really so important, I think, for the good and welfare of our society. I'm so pleased that the Social Justice Institute has invited me to present this inaugural Norman H. Stahl lecture, and in just meeting the judge and seeing the great, not only respect and admiration, but affection that everyone here has for him, I really am truly honored, a judge, and so pleased to be here tonight at this first lecture. I feel privileged also to be a part of this speaker series, and that two of my fellow Chief Justices, Linda Stewart Delanis here in New Hampshire and Wallace Jefferson in Texas, have been speakers before in this series. And I want to particularly say that it gives me such a pleasure and it's such an honor to speak at the law school where John Broderick is the dean. I can't think of a more towering figure in the fight for access to justice in New Hampshire or in this country. And I think we're kind of kindred souls of this particular focus that we have. But Dean Broderick, Chief Justice Broderick, has focused like a laser beam on access to justice, and he is truly such a singular figure in this country. And when I get an invitation from Dean Broderick, I say yes, whatever it is. And we had fun the other day in Baltimore, and I think trying to, again, preach the gospel. And so I thank you, Dean, for inviting me, and nothing gives me more pleasure than to be at this law school with this dean. So, many interesting things are being done around the country to promote access to justice and equal justice for all in the face of this terrible economy that has so impacted, above all, the most vulnerable in our society. In New York, I believe that our new pro bono bar admission requirement, which I'll talk to you about tonight, will make a significant contribution to these growing efforts around the nation. I want to give you a sense of what the new rule is all about, why and how we got there, and why I hope and believe that it will have a profound effect in the years to come on the legal culture, and most importantly, on those desperately in need of legal services, who face transformative crises affecting the very necessities of life, the roof over their heads, their physical safety, their livelihoods, and the well-being of their families. Beginning in January 2013, New York will become the first state in the nation to require applicants to the bar to perform pro bono work, 50 hours of law-related pro bono service before they are admitted to practice law. And I can tell you, there is much interest around the country in what we're doing because my fellow Chief Justices understand that it is critical that the judiciary take a strong leadership role on access to justice, which to me is the most critical issue facing the profession and the justice system today. I know this to be a major concern of Chief Justice Delanis, who spoke here at the law school about 3 weeks ago on addressing the unmet needs, legal needs in New Hampshire, and using pro bono to fill the gap. Our pro bono requirement for bar admission comes at a time when New York, like New Hampshire, and much of the country faces a justice gap between the need for legal services and the resources that are available. I know that New Hampshire's Access to Justice Commission, which was established through then Chief Justice Broderick's leadership, will soon be releasing a study that quantifies the unmet legal needs of this state's low-income residents and make recommendations for meeting those needs. In our address a few weeks ago, Chief Justice Delanis called the current state of access to justice a crisis of injustice. She also pointed out that only a fraction of the need is being met as the courts are seeing a steady rise in the number of pro se litigants. I couldn't agree more. Every year, we see millions of people coming into our courts seeking the protection of our laws without legal representation. They are confronting the threat of eviction or foreclosure by predatory landlords and lenders, abuse by a violent spouse or partner, losing custody of their children, and so many other issues that reflect turning points in their lives. And they include the most vulnerable among us, the elderly on fixed incomes, single parents, the disabled and mentally ill, abuse victims, and so many more. They are left to navigate a complex justice system and to advance for themselves and to advocate for themselves without a lawyer. So many of our courtrooms in New York are standing room only, filled with frightened, newly indigent litigants who are without anyone to help them, guide them through a process that is so totally unfamiliar and intimidating. Unfortunately, only a small fraction of people in need are lucky enough to be represented by a provider of free legal services. In New York City, 8 of 9 people seeking assistance from the Legal Aid Society have to be turned away because of a lack of resources. The situation is not very different here in New Hampshire, where providers are also facing a gap between declining resources and growing needs for civil legal services. The New Hampshire Bar News, referring to the forthcoming release of the Legal Needs Study, described the gap as shocking. The magnitude of this problem is so great, and the impact on the lives of unrepresented litigants is so dramatic. Access to justice is not a luxury, affordable only in good times. And it is in the worst of times that access to justice becomes so crucially important. It is a fundamental principle of a society based on the rule of law and transcends the vagaries, the up and downs of the economy. And for the judiciary and the legal profession, equal justice for all is our very reason for being. The rule of law itself loses its meaning when legal protection is available only to those who can afford it. It has been a central priority for me as Chief Judge to tackle this crisis. Nothing is more important to me. The judiciary and the profession, whether it be here in New Hampshire or in New York, have an obligation to foster equal justice to each and every human being. We cannot hope to meet that obligation if we fail to take action, particularly given the troubled economy. My approach to tackling this crisis began in 2009, when I announced that I would hold annual hearings to assess the unmet civil legal services needs in New York. I just finished the third round of these hearings, one in each of our 4 appellate departments. At the same time, I created a task force to expand access to civil legal services, chaired by Helene Barnett, the former president of the Federal Legal Services Corporation. At that point, we had seen a decline in funding, not only from the Legal Services Corporation, but from IOLA, the New York State Interest on Lawyer Account Fund, where revenues dependent on interest on attorneys' accounts dropped from $36 million a few years ago to $8 million in just 1 year. Other revenue streams in New York were neither stable nor dependable. I know that here in New Hampshire, your IOLTA grants, which like New York's IOLA had been a major funder of civil legal services for the poor, have declined from $1.7 million in fiscal year 2008 to $650,000 in fiscal year 2013. From the start, the hearings and the task force have been focusing on measuring the ongoing unmet need for legal services and how to quantify that need. We were able to obtain support from our legislature through a joint resolution urging the Chief Judge to measure the need and make recommendations to the legislature on how to fill the gap in available resources. The result is that we've been able to obtain critical funding for civil legal services in the judiciary budget over the past 2 years, and I could tell you every year is a struggle. I think of this, what we've tried to do in New York, as a template for New York and hopefully elsewhere. We hold hearings around the state, and based on those hearings and the recommendations of the task force, we then put money in the judiciary budget to narrow the justice gap. And the reason we put those monies in the judiciary budget is that access to justice is not tangential to what we do in the judiciary. Rather, it goes to the heart of our constitutional mission to provide equal justice. And that's why, at the same time that we were forced to lay off 400 employees 2 years ago, and it was very painful, when we had a $170 million cut in the judiciary budget, we still managed to obtain $27.5 million in new money for civil legal services. Why, with such a large cut in the budget, would we even begin to dedicate such significant money to civil legal services? Because it is not enough. The reason is it's not enough to just keep the courthouse doors open. If what happens inside our courthouses does not foster equal justice, then we might as well close the doors. It doesn't mean anything. Our commitment in the courts is not to running a business or a bureaucracy. It's about justice for all. It is fundamental to everything that we do. And this year, a much better year for our state financially. We were so pleased that we were able to get a judiciary budget that we could live with, which included $40 million in civil legal services money. This is by far the largest amount of public funding in the country, but let me tell you, it addresses just the tip of the iceberg in terms of the need, the urgent need for legal representation for the indigent, for the working poor, and for what the New York Times has called the near poor. people of limited means who cannot begin to hire a lawyer to deal with issues critical to their well-being and that of their families. With the greatly welcomed increases in public funding for civil legal services in New York, and our goal is to increase public funding by $100 million, we sadly know that there is still not enough money in the world to meet the tremendous need. Just think of the latest poverty figures. In New Hampshire, 8.8% of residents are living below the poverty level, and the rate for children is 12%. In New York State, 16% are living below the poverty level, with a rate of 23% for children. If you add those living below 200% of the poverty level that are eligible to receive free legal services from New Hampshire's main providers and from providers funded by New York State Judiciary Civil Legal Services money, the numbers are staggering. Even if an improving economy starts reducing these statistics, these are huge numbers impacting the lives of so many human beings and their families. And it could not be clearer to me that beyond public funding for legal service providers, the individual, voluntary pro bono efforts of members of the bar are absolutely necessary and critical. To their credit, so many lawyers in our state, like New Hampshire's lawyers, have embraced a culture of service. They recognize that pro bono service to others is a long-standing tradition and obligation of our noble profession. Lawyers enjoy an exclusive franchise to practice law and are in a privileged position, and that position carries with it an ethical obligation to use our skills and status to help meet those most in need. The American Bar Association has long maintained that every lawyer has a professional responsibility to provide legal services to those unable to pay. New York and New Hampshire's rules of professional responsibility echo the ABA model rules in strongly encouraging lawyers to provide pro bono legal services to benefit poor persons. But for all the valuable work of so many lawyers who selflessly answer the call, we need to think outside the box to mine untapped legal resources to address the ever-increasing need. In New York, although we made great progress and we're proud of that, we know that at best we are still only meeting 20% of the need for civil legal services in our state. It is in the context of the unmet need for civil legal services that New York's new pro bono requirement for applicants to the New York Bar emerges. Think of how many people in need that thousands of soon-to-be lawyers can reach. People who are at risk of losing their homes, victims of domestic violence facing deportation, or individuals who have been denied the disability or unemployment benefits they desperately need in order to get by. We hope to imbue new lawyers with lifelong habits. Performing legal work for the poor will give them an invaluable window into the real world. And contact with people so desperately in need of assistance can only help build empathy and understanding among the strongest factors that motivate lawyers to do pro bono work throughout their careers. The road to the new pro bono bar admission requirement in New York began on Law Day 2012, when I announced in no uncertain terms that prospective attorneys would soon be required to do 50 hours of pro bono work before they could be admitted to the bar. And to be quite direct, I didn't take a poll and I didn't wring my hands about what the reaction would be. To me, this step is fundamental to my own responsibility to exercise leadership in closing the justice gap so that the judiciary in our state can meet its constitutional mission of providing equal justice. I believe that the judiciary and the profession must be bold and proactive if we are to ensure that the ideal of equal justice is a reality in our respective jurisdictions and in our nation. The bottom line in my thought process was that the idea of law students using their legal training and skills to help those most in need was conceptually unassailable from both an ethical and practical perspective, and so in keeping with the nobility of our profession. I decided that Law Day was the perfect day to announce this initiative, although I knew there would be many questions still to be resolved. Recognizing the complexity of those issues, we formed a broad-based advisory committee to facilitate the implementation. The committee spent the entire summer on the project. They convened roundtable discussions, communicated with our State Board of Law Examiners, received input from lawyers, students, and law schools in New York and around the country, met with the leadership of state and local bar associations, heard presentations from legal service providers and government law offices, and had extensive discussions with Esther Lawden at the Pro Bono Institute in Washington, D.C. The New York Times devoted a large space to letters of criticism and praise. Should this initiative be replicated in every state in our country, or are law students just too inexperienced or too overburdened to perform meaningful pro bono work? We took it all in and crafted recommendations. The committee took into account the views of so many groups, yet always kept in mind the goal of inculcating newly minted lawyers with the core values of our profession, of which service to others is so much a part. On September 20th, I announced the new rule of the High Court, effective January 1st, 2013. In short, prospective lawyers must satisfy the 50-hour requirement through qualifying law-related work if they plan to be admitted to the New York bar, if they plan to call themselves a lawyer in New York. Briefly, let me run through the basic provisions, essentially the who, what, where, when, and how. The requirement applies immediately to all first and second year law students. We gave third years a buy, understanding that they had already registered for classes without knowing what the particulars of the requirement would be, and having listened to the law schools when they told us they needed more time to build the infrastructure to help match students with volunteer opportunities. What would constitute qualifying pro bono work? We had a major debate about whether we should limit pro bono work to the traditional pro bono area of legal service for the poor and unrepresented. We decided that that definition would be too narrow in this context and might make it difficult for law students to find projects meeting the requirement. So we included public service with the federal, state, or local government or the judiciary. We also added legal services to not-for-profit institutions, which seemed to make sense in terms of the spirit of the rule. We wanted to make the rule as inclusive as possible, and we wanted to make sure that there were enough opportunities available. While the great majority of the pro bono work students choose to do will help the poor and the disadvantaged, and that is my primary focus, I believe that law-related public service and public interest work are properly under the pro bono umbrella for purposes of the rule. The qualifying work obviously must be legal in nature, and I think everyone here knows the various ways that a law student or unadmitted law graduate properly supervised can help, like legal research and drafting, assisting with trial preparation, engaging in community legal education, or helping low-income clients to complete forms, and so much more. Obviously, they are not on their own being asked to represent murder defendants or to stop a big bank from foreclosing on a house. Depending on the nature of the project, the pro bono work is going to be well supervised by a lawyer, a law school faculty member or instructor, or a judge. We also decided that the pro bono work could qualify under our definition if it is part of a summer job, an internship, or an externship, including a judicial clerkship or other government service, even if the student receives a stipend or salary. We went further to include working on a law firm's pro bono cases while employed as a summer associate, as long as the client receiving the services isn't getting charged. That's the key factor in my mind. And we wanted to encourage the big law firms to have their summer associates do pro bono work. Believe me, in New York, they don't know what to do with these kids anyway. Where the work should be done in terms of geography was a much discussed issue. About 15,000 people sit for the New York State Bar exam every year, including, by the way, 33 graduates from this law school in 2012. Between 9,000 and 10,000 who take the exam are admitted, but only about a third graduate from our 15 New York State law schools. Another one-third are from law schools outside of New York, and the rest from foreign jurisdictions. In the end, it didn't make sense to us to require all of them to come to New York for the sole purpose of fulfilling the requirement. I'd love them to all come to New York and do pro bono work, but it just didn't make sense to us. So candidates will be allowed to perform their pro bono service elsewhere, and who would argue with that? Legal assistance to those in need obviously does not stop at state lines. Another issue as to where the work could be done was whether it could be at a student's law school in clinical or similar experiential programs for which the student gets credit towards graduation. Law schools with pro bono requirements for students sometimes do not count clinical programs as pro bono. However, for our purposes, the law school infrastructure is a perfect vehicle to make opportunities available to students through clinics and other means. Throughout the country, law school clinics are in place. They're well established, they're supervised, and they provide a first-rate experience for students, as is true of the clinics here at this great law school. And that will decidedly, in our mind, qualify to meet our pro bono requirements. And as to the when the work must be done, applicants have until the moment they actually submit their application for admission. Doing 50 hours of pro bono work over 3.5 years, approximately 7 work days, should not be onerous or burdensome to law students, regardless of their situation. When it's time to apply, the applicant shows compliance by completing a simple affidavit to document that the work was done and obtaining a supervisor's certification that that's the case. I'm proud that we're the first state in the country to take this step, although I always ask myself, if this is such a great idea, why hasn't anyone done it before? I think that's always a good question. The bottom line, at least as I see it, is that all of us, the judiciary, the profession, and the academy, have not exercised enough of a leadership role in access to justice and filling the justice gap that so obviously exists in our nation. Particularly in this depressed economy, it is so apparent that persons of limited means desperately need legal representation that they cannot afford. If we don't stand up for the poor, when there is a crisis in legal services in our country, no one else will. It is our mission and it is our responsibility. Requiring 50 hours of pro bono work from law school students was a no-brainer in my view. For the student, I believe doing this work will be infectious. They're not going to stop at 50 hours. Once they get involved in helping people and getting the satisfaction that comes with it, they will want to see the projects to completion and to do more. And I can tell you, when we held a press conference at the end of September to announce the rule, students from 2 of our New York law schools came in to talk about their pro bono experience in law school. Their stories were so incredibly powerful. Anyone hearing them speak could only think that nothing more needs to be said as to why law students should do pro bono work. Virtually every student I've met is enthusiastic about the prospect. They get it, and they get why it's important. Besides getting a chance to learn real-world skills and apply themselves outside the classroom, can make students so much more practice-ready and marketable to potential employers. As one student said, law school taught him to think like a lawyer. Pro bono work taught him to be a lawyer. Some even find their life's work through their pro bono experience. I also think that requiring pro bono service for admission to the bar has not previously been done because, quite frankly, it has been seen as a prelude to mandatory pro bono for all lawyers. With all due respect, that's not what this is all about. The next generation of lawyers must understand that pro bono is a core value of our profession, and it is a noble profession. The best safeguard for never having to resort to mandatory pro bono is to instill that culture of service in new lawyers at the very beginning of their legal careers, a spirit of serving others that will carry them throughout their years in the legal profession. In New York, the bar really has given selflessly, providing more than 2 million hours of pro bono service every year. The same is true of the New Hampshire bar, which contributes many thousands of hours every year. I commend all of them for their efforts to those in desperate need of legal representation. I have no intention of mandating pro bono service for each and every lawyer in New York, although, as Seinfeld would say, not that there's anything wrong with it. Would it be a terrible thing if every lawyer in New York or New Hampshire had to contribute 50 hours of pro bono service to the poor and the disadvantaged? I really don't think so. But I recognize that there are legitimate economic, conceptual, legal, and logistical problems in putting a system like that in place. And the new bar admission requirement is not a stalking horse for mandatory pro bono, and there's no reason for the organized bar to be fearful that kids will devote their time to helping the poor and the disadvantaged. Not the bar here in New Hampshire. The point of this is that the commitment of the bar to do pro bono work, and the bar has been great, must be transferred to a new generation of lawyers, to aspiring lawyers, so that service to others becomes a part of their DNA. If we are ever to close the justice gap, this is so basic. Pro bono for law students is just one step among many that we must take together. Every society is judged by how it treats its most vulnerable citizens. And for the legal profession, the judiciary, and the law school community, we can and should be judged by whether we provide meaningful legal representation to the poor, particularly when the essentials of life, the very existence and well-being of real human beings are at stake. The consequences are every bit as important as when one's liberty is at issue. If we fail in this most basic of our obligations, we become easy prey for those who seek to undermine the justice system and the rule of law. It is my fervent hope that the new pro bono requirement in New York, and eventually I hope elsewhere, will make a significant difference in the lives of those who most need legal assistance. Help is on the way from a new generation of lawyers, like those at this great law school, who are dedicated and committed to ensuring that the ideal of equal justice for all is a reality in New York, here in New Hampshire, and around our great nation. Thank you so much.
He's generously willing to take a few questions from the audience, so if anyone would like to come up, there's mics at both ends of the aisles, and you can ask him your question. Thank you.
Thank you. Hi.
Thank you, Judge Lippman. Two-part question. First, from the perspective of the state bar admission folks, what do you anticipate the costs of compliance and enforcement to be? And second, from the perspective of the courts, did you have to relax the standards for law students appearing in court at all to implement this?
No, they're good questions. In relation to the enforcement of it, we've tried to make it as simple as we possibly could in terms of you just put in an affidavit, you get the supervisor's certification. In New York, and I'm not sure exactly how it works here, the character committee in each of our appellate departments take the documentation and interview the people involved. I anticipate we'll do some spot checks here and there. I don't think, you know, that it requires the third degree in a criminal investigation. But I do think that there is a coordination. We don't think it's going to cost really anything. What we've tried to do with and we have 4 different character committees in New York. We've set up with an ex-dean of one of our law schools. He's at his law school. It'll be a center place where the calls will come in, where people are asking how they can meet the pro bono requirement, you know, what the rules are, et cetera, so that we all keep on the same page, that the kids know, you know, what they need to do to meet the requirement. And then when they come into the character committee, they'll be asked about their experience, which is fine. And, you know, I just don't anticipate a big bureaucracy attached to it. Centrally, we're just trying to coordinate our admission requirements. In relation to law students being able to appear in court, we already do in New York what we call practice orders, which are each of the 4 appellate divisions issues practice orders where a law school or whatever, a clinical program will come in, ask us for an order, and we will pass an order. Basically, the only thing that's important, and the same thing with the program, is that the student be supervised, you know, and make clear that, because one of the arguments, and to tell you the truth, you know, I thought a lot of it was just resistance to change, to anything new. Some of the arguments were that, look, the kids, you're taking inexperienced kids and you're asking them to represent the most disadvantaged in our state. And to me, first of all, right now they have no representation, you know? But I think the key to it is supervision. We're not asking kids, you know, people say, oh, they're going to go in the middle of some huge case in federal or state court. Not happening. You know, it's the basic tasks of learning to be a lawyer, supervised by a lawyer. So I don't think we'll have to lower any standards. We're doing a lot of that, and I hope it won't be any great cost. The ones who have been complaining about the cost, not here in New Hampshire, are some of the law schools. Felt that, gee, what are we asking them to do? But once we kind of put out the rule itself and showed them that we're not trying to make this so difficult, just the opposite, the law schools have embraced it because, you know, the high cost, as the dean will tell you, of legal education today is in the clinical programs, you know, where the kids are doing a lot of pro bono work, and it's much more expensive to do that kind of work than doing a large classroom like this. But we found that the law schools, too, have embraced it. They get it. We did a program at the Cardozo Law School about what the law school's obligation is in terms of access to justice. And we had all 15 law schools in New York, and we had a great session. And so I think everyone is recognizing that this is about the future of our profession, that if we can't have law students understand that the legal profession is about service to others, then this profession is not going to live up to the noble, I used that word a number of times, tradition of what we're supposed to be all about. Questions? Oh, yeah.
Well, thank you, Judge Lippman. My name is Matt Soper, and I want to ask how you see this affecting foreign applicants to the New York Bar.
It's a great question. You know, we sort of grappled with that because particularly the master's programs at the different law schools, you know, all have a lot of foreign students. And, you know, there are really issues. We got all kinds of questions about what he wants to do. You know, come into the year, they come in, they do their program, and then they come in to take the bar, and, you know, and that's it. The big issue with them was really, would we require them to do the pro bono work in New York? And while I think, you know, different countries have very different legal system and views of what it means to do pro bono work, we've developed a system that basically they will have a more detailed affidavit as to what they did, but we're allowing them to do the work even in another country as long as it's consistent with our view of what pro bono service means. So I think it'll be all right. Again, I don't think it's an insurmountable barrier, and but it'll be interesting because, you know, in New York, we get so many foreign applicants that come in and take the bar exam because they want the New York credential if they're in a business world or international, the global economy today. And it'll be interesting because we'll have a lot of them who are going to have to do this. And we're going to see how it plays out. But I think we can make it flexible enough. If they'll tell us what they're doing, we'll see if it fits into, you know, to the room.
Thank you.
Thanks. Anybody else?
Thank you. I'd like to now ask Judge Stahl to come up. Let's get that person.
First of all, Chief Judge Lippman, you're a good man to have made the trip today.
Oh, right.
I hope you're not a white-knuckle flyer. Some people on days like today are. You know, when the dean first spoke to me about this some time ago, I was sort of reluctant. He was correct on that. But I do want to express to him, to the law school, my appreciation for sponsoring this lecture series on my judicial service. When I began the practice of law in New Hampshire in the dark ages, 1956, the thought of pro bono representation was not something that was really on anybody's mind. The bar was small. There were approximately 400 of us. I think when I took the New Hampshire bar, there were 25 people with me over at the old Supreme Court building in desks which are not big enough. We knew everybody. There were 400 odd members, as I say, and Of those 400, we knew who we could trust and who we could not, and there were very few that we could not. And when problems arose of having to represent people who needed representation and did not have the funds, it was an ad hoc sort of thing. I remember two instances, one before I became a member of the New Hampshire Bar. In the early 50s, there was a communist scare in this state, and some people were caught up in that, and lawyers from big firms and small, Joe Millimet was one, Hugh Bounds and others, came forward and represented these people at great financial cost to themselves and professional costs at a time when representing people in this state who had ideas which were not mainstream was at some personal risk. The other case which comes to mind was State versus Coolidge. Some of you may have read that case in your law studies. Coolidge was a man who was charged with 2 murders, I think, and tried on 1. And we didn't have murder cases to speak of in New Hampshire in those days. And the question was, how was he going to be represented? It was a pro bono representation. The Devine firm, the McLean firm, and the Wadley firm each produced a lawyer to represent the defendant, and Mr. Coolidge. And it was Matt Reynolds, Bob Chiesa, and John Graff. They were all young lawyers, and they worked terribly hard to give that man good representation. The case resulted in a verdict for the state, and the decision was made. There were some very interesting legal questions that they would seek cert. Matt came to me and said, where are we going to get somebody to help us? I said, well, I'll call Paul Freund at the Harvard Law School, and I did. And I said, Professor, would you be willing to help? He said, no, I haven't got the time, but Archie will probably do it. Archie was Archibald Cox. And we called him, and I remember a Saturday morning, a beat-up old car showed up in front of our office at 1838 Elm Street, and Archibald Cox came out with an old beat-up briefcase. He came into our conference room and sat down at the table with the 3 boys, and I think I was there too, and he drew up the cert petition, which the Supreme Court granted, and Cox went to the Supreme Court and argued the case, and of course the case came back here on a very important issue. That was the way pro bono work happened in those days. People did it because it was necessary, and we were not very well organized. That can't happen today, and today it's a very, very different ball game, and we need the sort of thing that the Chief Judge has enacted in New York, and we're going to have to consider this across the country. Those of us who do our job often say, when we see a case, we say, what a sad thing that these people did not have adequate representation, because there really is an issue, and if it was presented properly, the results might be very different. And so what the Chief Judge has come up with is an excellent idea. It's good for the law students, it's good for the bar, and hopefully it's going to be good for the public. For all of you who chose to come here tonight, particularly my law clerks, some from a great distance, I thank you all. I've been very fortunate with the friends that I have in the New Hampshire Bar, the state and the federal judiciary coming here tonight. I think, as I look back on the last long time, I guess, at this point, I never thought I would be a federal judge when I started practicing in New Hampshire. It was a very, as I say, a very different place. I've been very lucky. I've had a very good career. I've had the chance, I think, to try to get it right, which is what I think all of us who do this job do want to do. We want to get it right, and we do our best. We do not always get it right, and the public sometimes doesn't understand what we do and what we have to do. But I do know that the American judiciary, I think if the founders were alive today, they'd say it's pretty much working as we expected it to work. And for that, I think those of us who do it say, well, that's a good thing. Chief Judge Lippman, I understand that the law school presents everybody who's willing to make the journey to New Hampshire with a gift in honor of their coming. This is the gift. I understand it's done by a local New Hampshire artist,
Thank Chief Judge Lippman. I wish that virus was contagious all across the United States, and thanks to him, I think it will be. Before we close tonight, I want to welcome all of you to come to a reception, which will follow, which is co-sponsored by the law school and Norman's firm of Divine Unmet. And so I want to thank the firm for doing that. I also want to acknowledge and recognize two people here tonight. To their embarrassment, I'm sure. The first is a former law clerk of Judge Stahl's, Gordon McDonald, who's seated here in the front row. Gordon McDonald is currently spending hours and hours of his time, rather than doing billable time at Nixon Peabody. He's helping New Hampshire legal assistants raise money across this state. And I want to acknowledge what he's done. I also want to acknowledge what his firm has done. The New Hampshire office of Nixon Peabody has about 20 or 25 lawyers. Last year, each of those lawyers, on average, did more than 100 hours of pro bono service. I think that's remarkable, and it should be recognized. And the second person I want to recognize will be offended that I've done it, because I do it whenever I can, and he never likes it. So I'm going to do it again. John Tobin, who's here tonight, he always says, talk about my staff, my lawyers, don't talk about me. So when I recognize him, I'm recognizing them too. John Tobin has been at this wheel for a long time. He's been at it when no one was looking, when no one cared, when no one helped, in times when they closed offices and then days when they open new offices. His resolve has been the same. And I mean it when I say, when I look across the New Hampshire bar and the history of the bar, there are some people that jump out at you that are heroic in your mind. John Tobin took his Cornell law degree and spent it on people who could never otherwise afford it. It's an example, I think, that we should all adopt. And I was thinking tonight, Chief, as you were talking, what John Tobin, after all these years, must be thinking about your remarks. It was like the cavalry has come, and they've come from New York. So, John, thank you for what you do and your staff. And we now have a reception. It will last 8 minutes. I hope you'll stay and talk to colleagues and people you may not have met. Thank you for coming tonight. It's a great honor to have you at the law school.